This 1963 House of Lords negligence case has been overtaken by the various civil liability acts in Australia, but it remains important for understanding the foundation for what is called negligent misstatement causing pure economic loss. Negligent misstatement occurs when someone, usually a professional, has a duty of care to ensure that the advice they give, which others are going to rely on, is reliable. In this case, Hedley Byrne were an advertising agency. They were approached by a firm called Easy Power, who initially wanted to spend £8,000 to £9,000 on advertising. This was a fair amount, so Hedley Byrne asked their bank, National Provincial Bank, to contact Easy Power's bank, Hedley Partners, to confirm that Easy Power was in a financial position to enter such a contract. Hedley Partners said that Easy Power was a subsidiary of a larger corporation which was in liquidation, but that Easy Power itself was trading successfully. A few months later, Easy Power were clearly ramping up their advertising efforts, and Hedley Byrne sought Hedley Partners' reassurance that Easy Power was good for £100,000. Hedley Partners replied in a letter headed "For your private use and without responsibility on the part of this bank or its officials." The letter said that Easy Power was a respectably constituted company considered good for its ordinary business engagements. Your figures are larger than we are accustomed to see. Relying on that advice, Hedley Byrne went and started purchasing advertising space on behalf of Easy Power. Easy Power then went broke, and Hedley Byrne lost around £17,000, a lot of money in the late 1950s. Hedley Byrne sued the bank, claiming that the bank's negligent misstatement was the cause of its loss. The bank relied on precedents that there was no duty of care for mere statements. The bank also argued that even if there was a duty, the without responsibility clause saved them from any liability. The court found that there was a duty of care. Lord Borthey Guest gave the classic statement, "If someone possessing special skill undertakes to apply that skill for the assistance of another person who relies upon such skill, a duty of care will arise. The fact that the service is to be given by means of words can make no difference." However, the court found that the exclusion clause, the without responsibility clause, was effective, and so the bank avoided liability.